Welcome back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas. Today I'm going to make a very bold claim, and that is I personally got the United States Citizenship and Immigration Services, otherwise known as USCIS, to update a section of their Form I-485 application to adjust status, which first came out in 1967. So in case you're new to immigration, the Form I-485 is a very common form. If a foreign national comes to the United States and they want to remain in the U.S. permanently, this form must be completed. As you can imagine, millions of people so far have filed this form since 1967. So before I start this video, let me just say that just like all of my other YouTube videos that are backed by client testimonials or screenshots, I brought the receipts to show that what we did can be reflected on the newly revised I-485 application version that was recently released just 2 months ago. So back in November 2020, one of our clients filed a marriage-based green card application by themselves. This means that they had to submit the form I-485 to apply for a new green card. In January 2022, our clients received a denial notice, which led them to find and hire our office to help them. After reviewing the facts of their case and reading over the denial decision, I had to explain to the clients that the immigration officer denied the wife's green card application because they are claiming that she lied on her prior applications or visa interview and that she was a liar. The government also said that if she wants to reapply or appeal the decision, she would need to admit to being a liar and to file the Form I-601 to ask the government to forgive her for lying. According to the immigration officer, when she applied for her initial B1, B2 visitor visa to enter the United States, she indicated that she had stepchildren. However, now when she's applying for her green card application, she is stating that she has no children whatsoever. Although it is true that if you told immigration that you had children before and now you're indicating that you have no children, it would be suspicious and could be a red flag. However, when I spoke with the clients, the wife told me that during her immigration interview, she expressed to the immigration officer that she was previously married to her first husband and he had children, but after their divorce, she no longer considered herself as their step-parent. Her and her husband told me that they refused to call her a liar or admit to lying when they did not lie. To me, this made perfect sense. And this is the reason why I told our clients I think they should appeal the case. We filed the appeal and asked immigration to reconsider their denial decision sometime in February 2022. And I wrote a legal brief to explain why the client has never lied to the government about her children's status. And in the legal brief, we argue that being a step-parent is not an immutable characteristic. This means that if a woman marries a man with children from a prior relationship, she becomes a step-parent. However, if the same woman and the same man divorce, those children should not be considered her stepchildren any longer. I think most of you out there are highly educated, and our argument makes perfect sense. However, this is not the case with the federal government. We had to dumb it down even further on our legal brief to make sure they really understood. So what we did was we explained that since the children were not her biological children or she didn't adopt those children either, the client was not required to continue listing those children as her stepchildren on immigration forms. In the brief, we also argued that our client should not have to file the Form I-601 since she did not try to deceive or willfully misrepresent any facts related to her case. Now, it did take the government a while to make a decision, but this past June, the client finally received her green card. Then about 2 months later, on August 12, our client's I-290B appeal was officially approved and we received the approval notice. And coincidentally, 16 days after our approval, immigration published a revised version of the Form I-485. So what was so different in this form that was unlike anything else in all of the prior versions of this form that came out since 1967. In this new form, it has a special note. Now in the section related to information about children, it states very clearly, the term children includes all biological or legally adopted children, as well as current stepchildren. So there you have it, proof that our office personally got USCIS and the federal government to change a form that has been around since 1967. Now just imagine how many people over the last 57 years who have had their cases denied by immigration officers who did not have a basic understanding of stepchildren and step-parent relationships and their dynamics. This is exactly why you need an experienced immigration attorney by your side. Things that may appear easily understood on its face may not be easily understood by the federal government. So when you hire an immigration attorney, make sure that you hire someone with the experience necessary to get the job done. Although it took the government several decades to admit that the forms needed to be updated and changed and the officers needed to be retrained, I'm glad that they finally made this update to this particular section. Again, this is Winning Law, and thanks for watching.
At David Nguyen's Law Office, we are here to help you. We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the law office of David Nguyen.